Hello everyone. Well, social media is blowing up about the Cadre v. Meta case. And one thing that's painfully obvious is that these people don't know anything about the case, which means they haven't been watching my videos because I've been covering it. It's also the case that they don't know anything about fair use, and mostly these are authors whining that they stole our books to make the AI, and basically what they're doing is they're attacking fair use. Now, they deny that, and they insult people like me who try and educate them as to what fair use is about. But Meta just dropped it. They dropped the big one explaining what fair use is and clearly why AI training is a form of fair use. It is absolutely transformative. And if it's not fair use, then nothing is. Then what I do and other YouTubers and other small creators do is not fair use. And that means we all get shut down. That's the threat here. It's not just a threat to AI. It's a threat to everyone. This was filed 2 days ago as I record this, but it was really only put up that evening publicly, along with a whole lot of other documents that we won't go over. There is one that's interesting. They're past the fact discovery and they're just about to conclude expert discovery. And that's what this is. This is all of their experts submitting everything. And one of them is an expert on BitTorrent. And I read that, and most of it is what I knew. She made a few extra points that we might talk about during this, but I'm not going to go over what she said. But it's interesting if you want to know how BitTorrent works and how it's relating to this. Because what they're saying, they're going against what the courts have consistently said before, which is that if what you're doing is fair use, it doesn't matter how you got the material. So, for example, if you're a film reviewer, or even if you're not, if you just want to do a review, you go to the theater, you watch a movie, you say, well, that's terrible, I'm going to trash it. Well, you need a copy of the movie to do a proper film review because proper film reviewers show clips of the movie. What do? You go online and you download it. You don't have permission to do that. What if you did? What if you had to have permission to do that? What's in the news? Like the Disney Snow White is in the news. And Disney says, oh, that guy, he always negatively reviews our movies. Don't let him review Snow White. And they say, you don't have permission to use clips from Snow White in your review. That means you're only going to get the proper reviews with clips in the positive reviews, and the negative reviews are going to be inhibited. That's a situation you cannot have. And so that is fair use. Since what you're doing is a fair use, it doesn't matter how you get it. And they're turning that on their head now. This is a 53-page document. We're not going over all of it. In the contents, it starts talking about all of their exhibits from their experts and everything. We are going to go to page 27 of the PDF file. This is page 15, but I'm going to say 27 because the ones up at the top are blue, and that's the ones that are in the, like you type into the PDF file, go to page 27. At the bottom, it's 15 of the document, and we've seen that before. That's kind of confusing. So you can keep track of it better. I'll say 27. 53. Hey, we're more than halfway through already. Yeah, no, we're not. We're just getting started. I've said this before. If AI training isn't transformative, nothing is. And they're talking about here, the first factor, AI training is highly transformative. And remember, we've talked about this before. The idea of something being transformative predates the concept of fair use. And so it used to be that if what you had was transformative, that's it, you were done. There was nothing else to talk about. And then later on, they came up because not just transformative things are fair use. There are other things as well. But if it's sufficiently transformative, none of those other criteria matter. They say, under the first factor, purpose and character of the use, is the new use transformative, i.e., whether it merely supersedes the objects of the original creation, or instead adds something new with a further purpose or different character. And they say Llama is radically transformative at the most basic level. An LLM is nothing like a trade book. Unlike books, which consist of expressive text meant to be read, Llama consists of software and numerical weights containing no expressive text at all. It does not merely add something new, it is an entirely new technology designed to create novel, context-driven responses to a vast array of user queries. Time and again, courts have held uses far less transformative than Meta's to be fair at summary judgment. And that's the place we are now. Both sides are wanting their own version of summary judgment, and that's what these motions are about. And we're going to start with the Google books. Hey, we talked about that one. The Second Circuit had no difficulty concluding that Google's making of a digital copy of millions of plaintiffs' books for the purpose of enabling a search engine for identification of books containing a term of interest to the searcher involved a highly transformative purpose. Searching books is not an infringing use. The purpose of Google's copying was to make available significant information about these books, not reproduce them. Meta extracted information about the word usage in plaintiffs' books and other text to develop a new technology that serves a distinct purpose and does not permit users to read even one page of plaintiffs' books. Again, these things do not... They were saying this online just like 2 days ago, as recently as that. Oh, they're just compressed copies of the book. No, they aren't. You're showing your ignorance. You're either showing your ignorance or your willingness to lie, one or the other. The Ninth Circuit's Kelly decision is also instructive. We haven't talked about this one. This was a search engine that enabled users to search for images. To create this technology, Ariba used a crawler to copy images from websites without authorization, including Kelly's copyrighted photographs, which it stored and displayed as a thumbnail image in response to user queries, because that's what you do with those. The Ninth Circuit affirmed summary judgment for defendant, finding that this was a transformative fair use and reasoning that Ariba's use of the images serves a different function than Kelly's use, improving access to information on the internet versus artistic expression. And that's when you're making a direct copy of the entire image, just crunching down the size to a thumbnail, which isn't even what AI training is. Again, it's not crunched down books. It's not compressed books. There is no text anywhere in AI models. And HathiTrust, the other one we talked about, the Second Circuit also affirmed summary judgment, finding that copying millions of books to create a searchable database was quintessentially transformative because the result of a word search is different in purpose, character expression, meaning, and message from the page and the book from which it is drawn. They also talk about Oracle. We followed that when it happened. The Supreme Court's post-trial decision, the court held that the purpose and character of Google's copying of thousands of lines of Sun Java code was transformative and supported a fair use finding. This use, it reasoned, seeks to create new products to expand the use and usefulness of Android-based smartphones. Google's new product offers programmers a highly creative and innovative tool for a smartphone environment that can be readily used by programmers, and as such, its use was consistent with that creative progress that is the basic constitutional objective of copyright itself. Remember this. Always remember this. The purpose of copyright under the Constitution is not to enrich artists. It's not to reward them for wonderful things they've done. It's to promote the progress of science and useful arts. As long as it does that, the copyright is valid. As soon as it steps beyond that, it no longer is. Meta's Llama is even more innovative, transformative, and useful, and fulfills that same fundamental objective. And here's another one, Sony versus Connectix. The Ninth Circuit reversed a preliminary injunction, finding that copies of Sony code made to reverse engineer the PlayStation platform were protected fair use. Although competitive, the purpose of the copying was to create a new platform, the Virtual Game Station, which did not itself contain object code that infringes Sony's copyright. And that's something else they're whining about. Oh, it competes with us. So what? That has nothing to do with it. Does it copy your work? That's what it's about. Thus, the court was at a loss to see how Connectix's drafting of entirely new object code for its VGS program could not be transformative, even despite the similarities in function and screen output. Here, Meta made copies of plaintiffs' books to train Llama on statistical information about their language and syntax without including any protected expression in its code or weights. It's just those aggregate statistics about how many words they use and how often and what words follows others. That's what it's using. It's not copying the expressive content. It's just an aggregation of all English speakers. That information is then used to enable Llama to perform functions and create outputs completely unrelated to and different from reading plaintiffs' books. Llama is thus precisely the kind of highly creative and innovative tool the Supreme Court found to be consistent with that creative progress that is the basic constitutional objective of copyright itself. And again, like I said, it doesn't matter if it's commercial. Transformative works are at the heart of the fair use doctrine's guarantee of breathing space within the confines of copyright, and the more transformative the new work, the less will be the significance of other factors like commercialism. The more transformative it is, the less other things matter. Thus, the Supreme Court has often held that for-profit uses are fair. Here, Llama 1 was released solely for non-commercial research purposes. Later versions are available for free in most cases. Yeah, you can just download it. Download it and use it yourself. Nevertheless, Meta acknowledges that it is a commercial enterprise and that Llama is used for both commercial and non-commercial purposes, and that Meta hopes one day to recoup its significant investment in this important new technology. Under the above authorities, the first fair use factor still weighs strongly for Meta, given Llama's highly transformative purpose. And again, all this applies no matter how it acquired the works. Plaintiff's motion is almost entirely devoted to castigating Meta for copying, via both direct download and torrent, large third-party datasets that Meta did not create but knew contained pirated works. Plaintiffs argue that copying entire works from pirated databases to avoid compensating the rights holder cannot be fair use, and that for fair use to apply, the work that was copied must have been lawfully acquired. But again, if you have permission, you don't need the concept of fair use. You just have permission and you can just use it. The whole point of fair use is that you can use it without permission. Every case of alleged copyright infringement involves an unauthorized use of the plaintiff's work. Often, a defendant makes a fair use knowing the copyright holder would not consent, like our movie reviewer. Courts recognize, after Oracle, that the concept of good or bad faith has little influence one way or the other on the fair use analysis. Bad faith is not, and this is something they're trying to say, they're doing the whole Cardinal Richelieu thing. You know, show me 6 lines written by the most honest of men, I'll find something in it which will hang him. They're going through all this discovery and all that, and they're pulling out like little snippets of emails. Haha, see, they knew they were doing something wrong. Doesn't matter. Doesn't matter. Bad faith doesn't matter. Bad faith is not dispositive of the fair use question or even the first factor, which still favors defendants in light of the transformative nature of the secondary use. Little influence one way or another, they just said. So bad faith doesn't mean you've infringed any more than good faith means you haven't infringed. Has nothing to do with it. This is consistent with copyright's objectives. Copyright protection is not withheld from authors who lie, cheat, or steal to obtain their information. That has no bearing on copyright protection because copyright is not a reward for goodness, but a protection for the profits of activity that is useful for the public education, to promote the progress of science and useful arts. Likewise, fair use focuses not on the morality of the second user, but on whether her creation claiming the benefits of the doctrine is of the type that should receive those benefits, with a primary focus on whether the secondary use is productive and transformative, and whether it causes excessive injury to the market for the original. Fair use is an objective inquiry into what a user does with an original work, not an inquiry into his or her subjective intent. Under Oracle and Goldsmith, it does not matter whether Meta downloaded datasets containing pirated books from a third party who lacked authorization to distribute them, or borrowed 49 used books from the library and scanned them by hand to achieve the same result. Its use was undeniably transformative, and any attempt to overcome that inevitable conclusion with rhetoric about Meta's subjective mindset, even if credited, is unavailing as a matter of law. The only case plaintiffs cite for the proposition that a party invoking fair use must use an unauthorized copy of a work is Atari v. Nintendo, which doesn't help them either. Atari acquired Nintendo software code both by reverse engineering Nintendo chips and by lying to the U.S. Copyright Office to obtain it. The Federal Circuit found that Atari's reverse engineering to build its own competing program, though unauthorized, was fair use, while the use of the purloined source code was not. Without analysis, the court cited Harper and Row for the proposition that knowing exploitation of a purloined manuscript is not compatible with the good faith underpinnings of fair use, and extrapolated a rule nowhere announced in Harper and Row that to invoke the fair use exception, an individual must possess an authorized copy of a literary work. That's the only case they have that says what they want to say, and yet it's a complete misuse of Harper and Row, and it's been superseded as we're about to see. Plaintiffs' singular reliance on Atari betrays the fundamental weakness of their argument. Atari is not good law. It is an outdated, out-of-circuit case that misstates the holding of Harper and Row and has been superseded by Campbell, Oracle, and Goldsmith. It is also distinguishable on its facts. Plaintiffs cannot dodge a fair use finding by asserting that the copies Meta made to train Llama were unauthorized. Even assuming that to be true, Factor 1, like all other factors, weighs strongly in favor of fair use given Llama's indisputable transformativeness. In Connectix, the Ninth Circuit held that copying software code to access its unprotected functional elements was fair use. Key to the analysis was that if Connectix was to gain access to the functional elements of the software system at issue, it had to be through a form of reverse engineering that required copying the system at issue onto a computer. There was just no other way to do it. Alright, now this is probably the most important part of this video. If you watch no other part of this video, understand this. Although plaintiffs' works are creative, the aspects of the works that Meta needed to extract and use to train Llama are unprotected statistical data regarding word order, frequencies, grammar, and syntax, i.e., unprotectable information about plaintiffs' use of language relative to all other training data rather than their protected expression. It's just a statistical analysis of how people who write in English use words. Their grammar, their form, their syntax, their usage, their style. As before, there's just no other way to do it. The necessity to access unprotected aspects of works as to which plaintiffs had already exploited the commercially valuable right of first publication tips the second factor in favor of fair use. See Google Books again. Google Books further refined the inquiry, noting that what matters is not so much the amount and substantiality of the portion used in making a copy, but rather the amount and substantiality of what is thereby made accessible to a public for which it may serve as a competing substitute. So this isn't about how you get it, it's about how you use it. That's why it's fair use, not fair getting of or whatever. Courts routinely find that copying an entire work is fair where reasonable or necessary to achieve the purpose of the fair use. Like with our film critic, in order to get the clips, he's got to download the whole movie. He can't just download the clips. That's not how it works. He has to download the movie and select the clips. And they go back to Kelly too. It was reasonable to copy each of Kelly's images as a whole, as copying only part would reduce the usefulness of the visual search engine. Because it was reasonably necessary for the Hathitrust digital library to make use of the entirety of the works in order to enable the full text search function, we do not believe the copying was excessive. And then they go all the way back to Sony Betamax. Finding technology for recording entire programs was fair use, and noting the fact that the entire work is reproduced does not militate against the finding of fair use. Google Books is highly instructive on Factor 3. In that case, Google made a digital copy of the entirety of each of the plaintiff's books to create a tool that could search for words within these books and return snippets containing them when prompted. With significant effort, plaintiffs' experts were able to use the tool to access and reproduce no more than 16% of the text of the books. While Google makes an unauthorized digital copy of the entire book, it does not reveal that digital copy to the public. The copy is made to enable the search functions to reveal limited, important information about the books. With respect to the search function, Google satisfies the third factor test as eliminated by the Supreme Court in Campbell. And likewise, Llama's utility depends on copying whole books and many other data sources, and plaintiffs openly acknowledge that. We covered that. They said it. It cannot be done any other way. Thus, Meta's use of whole books to train Llama was necessary for its fair use purpose of creating a transformational LLM. Moreover, Meta's use does not make any significant portion of the text available to Llama users. Experiments by the party's experts show that Llama can be forced through determined, assiduous, time-consuming prompt engineering to make accessible at most only a few frequently quoted passages, usually less than a paragraph, from only some of plaintiffs' books. They have to be frequently quoted so that it's in the training data enough, because otherwise it's not going to be able to do it because it doesn't have it. It can't reproduce text that it doesn't have. These passages constitute far less than 1% of any work and pale in comparison to the reproduction found fair as a matter of law in Google Books. And Llama's inability to generate outputs that substantially replicate training data is by design. They don't want it to. If they go on, regurgitating text quoted by others, that's the LLM not working like it's supposed to. Meta trained Llama on a massive volume of data to ensure that no one work meaningfully influences what Llama can generate. Indeed, plaintiffs do not even allege any infringing outputs. Thus, if the third factor thus weighs in favor of anyone, it's Meta. Again, if this isn't fair use for Meta, then there is no fair use and they can go after any one of us. So the fourth factor examines the potential market effects, asking whether it will cause harm to the actual or potential markets for the copyrighted work. And what they're screeching about all over social media is not what that means. Again, going back to our movie reviewer, if he's an influential movie reviewer and he says, don't go see this Disney movie, and people listen to him and don't go see it, that's harm. He's caused them financial harm, but it's his right to do that. That's not what this is talking about. Here, this factor strongly supports a finding of fair use because Llama does not provide a substitute for plaintiffs' works in any relevant market and has not caused plaintiffs any cognizable harm, but does provide tremendous public benefits. When defining the relevant market, the inquiry is not whether the disputed use harmed any market for the original work, but rather whether the use served as a substitute in a market the copyright holder reasonably expected. As the Supreme Court has acknowledged, it is a given in every fair use case that plaintiff suffers a loss of potential market if that potential is defined as the theoretical market for licensing the very use at bar. To avoid this vice of circular reasoning, courts emphasize that the relevant inquiry is not whether the disputed use harmed any market for the original work, but rather whether the use served as a substitute in a market the copyright holder reasonably expected. And that goes back to the Warhol case, the basis for that case, which, yes, is roundly criticized, and it seems like the Supreme Court is kind of moving away from it a little bit. But the idea was that since the Warhol version of the Prince photograph served the same purpose as the original Prince photograph, in other words, it was used in a newspaper article about Prince, then that meant it was infringing. The copyright holder cannot prevent others from entering fair use markets merely by developing or licensing a market for transformative uses of its own creative work. Hey, we're going to set a thing where if you pay us $1 bajillion, then you can license it and do it. Yeah, well, we're just going to do it anyway by downloading it. No, that's not fair use because we made this market available. Nope, nothing to do with it. Nothing to do with it, still fair use. made even more dishonest by the fact that they're not setting up any such thing. A lethal parody, like a scathing theater review, may kill demand for the original, but that would not be cognizable under the Copyright Act. Instead, the fourth factor asks whether consumers treat a challenged use as a market replacement for a copyrighted work. That inquiry is concerned with only one type of economic injury to a copyright holder, the harm that results because the secondary use serves as a substitute for the original work. Plaintiffs cannot show any cognizable substitutive harm from llama. Plaintiff's expert, Dr. Spulber, likewise did not cite any evidence of lost sales. He did not even evaluate it, didn't even look at it, didn't even count it. Industry data assessed by Dr. Sinkinson and unrefuted by plaintiff's experts further validates that llama's broad release had no discernible effect on book sales. Plaintiff's inability to demonstrate harm is not surprising. They do not identify any instance in which llama has ever outputted their books or anything that could substitute for reading them. Unable to show harm to normal markets from Meta's copying their books to train llama, plaintiffs resort to asserting that they were deprived of a license fee for that use. That's circular for three reasons. 1. Plaintiffs' copyrights do not extend to any market for transformational use. 2. There was no market to license plaintiffs' works for LLM training when Meta copied datasets containing them, and there still is not. And 3. No such market is likely to develop. As the Supreme Court and Ninth Circuit have repeatedly concluded, the secondary user's failure to obtain a license in order to pursue a transformative use, even where the parties had engaged in negotiation for such a license, does not weigh against fair use. This is just a complete non-point, so stop making it. And there isn't even a circuit split here. Courts outside this circuit agree. A copyright holder cannot prevent others from entering fair use markets merely by developing or licensing a market for transformative uses of its own creative work. All right, we're going to skip on a bit. All right, let's go to page 45. Plaintiff's motion asserts two grounds for summary judgment in plaintiff's favor. Both fail. First, plaintiffs seek a finding that Meta violated their Section 106.1 reproduction rights based on Meta's large-scale copying of the books without plaintiff's permission. Meta's copying of plaintiff's books constituted a transformative fair use and thus was not an infringement of copyright under Section 107. Plaintiff's request for summary judgment on its Section 106.1 claim should therefore be denied. Plaintiff's second argument for summary judgment, though convoluted, is equally meritless. They assert that Meta's initial acquisition of their books cannot be fair use, as Meta downloaded them from known pirated databases, including via torrent, and re-uploaded to other online pirates at least some quantity of that pirated data as part of the peer-to-peer sharing process. This is where we're going back into that seeding thing again. None of this holds water. Section 106 does not provide a right of acquisition. It provides for exclusive rights of reproduction. And again, this whole thing is being deliberately conflated. It's not about how you get it, it's about how you use it. It's fair use, not fair getting. Any argument premised on Meta's alleged distribution of plaintiffs' works is not properly before the court. Plaintiffs do not move for summary judgment that Meta violated Section 106.3, and for good reason. Plaintiffs have not asserted, much less put forth undisputed facts to prove that Meta distributed any of their works. Indeed, the most they can muster is that at least some quantity of the data Meta downloaded via torrent must have been re-uploaded. And remember, burden of proof is on the plaintiffs and they need to show that. But again, if you read the expert testimony of their BitTorrent expert, maybe I'll dig that one back up and put a link in so you can see that. Even the plaintiffs acknowledge what I pointed out back when we first started talking about this. There are ways to prevent you from seeding any of the blocks. And their expert pointed out something that I neglected that I'm kind of embarrassed that I failed to think of, which is their firewall would have prevented it. Firewalls prevent unsolicited incoming connections. So anyone who says, hey, they've got a copy of this, I want to go get some of it, they wouldn't be able to do it. And even if they can say that a few of them slipped through somehow, first of all, these blocks we're talking about are 16 kilobytes. It's not much. Certainly not enough for the entire work, and also it has to be a part specifically of the plaintiff's works. And they would need to show that would happen more than enough to constitute de minimis copying, which, as we covered, is one of their defenses. And as the expert also pointed out, we're not talking about ASCII text here. Like, depending on what format it's in, if it's an EPUB format, an EPUB is basically all the HTML and graphic files and everything else. They're zipped up. And then you just rename the .zip file to .epub. Well, that's compressed, and so it's all glommed up. And so what you're giving them is this glommy noise that has no meaning outside of the rest of the pieces in that file. So they have just a bewildering amount of just such a difficult burden they would have to go through to show any of that. And again, like I said, by doing that, they're basically giving up on the whole AI aspect of this case to begin with. And they're basically no longer claiming that AI training itself is a derivative infringing use. That does not even suffice to raise a genuine issue as to whether any distribution of plaintiff's works occurred, much less allow the court to determine as a matter of law that Meta's copying of plaintiff's works was anything but fair. Seeding is the only form of distribution alleged, and until the court's recent order allowing the expert report of Dr. Chofny's and further discovery on leaching, the only theory at issue in the case. Thus, fact discovery is newly underway as to leaching, and Meta has sought leave to file its own expert report on leaching. Spoiler alert, he allowed it. The plaintiffs kept screeching, "No, you shouldn't be allowed to have an expert to rebut our expert." Just said, "What are you talking about?" Of course they can, and allowed it. A topic it has not yet had an opportunity to address. As to seeding, plaintiffs no longer appear to be pursuing this theory. Oh, another claim just drops off the card. They're going away fast. Plaintiffs now concede that Meta used a script that worked to prevent seeding that pirated data after downloading was complete. Plaintiffs' motion also comes nowhere close to establishing that Meta distributed any of their works by leaching. Because again, even when you're leaching, you're still seeding some of the blocks that you've already downloaded. But again, you can stop that like with a firewall or with other configurations of the client, and the plaintiffs acknowledge all of that. The only purported evidence they cite for this is the Chofny's report. That unsworn report is not attached to a supporting declaration, is not admissible evidence. It's just a rando saying stuff, and should be excluded from consideration of plaintiff's motion. Even if the court were to consider it, Dr. Chofny's opines that there is a greater than 99.99999% chance that Meta uploaded at least one piece of plaintiff's works. That opinion is based on faulty reasoning, as Meta's expert, Ms. Fredrickson Cross, attests in her declaration, raising at the very least a genuine issue of disputed fact on distribution. And even if the Chofny's report were credited, the most any fact finder can infer from it is Meta uploaded an unspecified amount of an unidentified work to an unidentified recipient, which falls far short of establishing that Meta distributed any plaintiff's work via leaching. In sum, plaintiffs cannot rely on disputed allegations that Meta distributed their works, a determination on which they do not seek summary judgment, and implicitly concede that they cannot establish as a matter of law to overcome Meta's defense that its copying of plaintiffs' works to train Llama was fair. Let's go to the bottom of page 48. What plaintiffs ask the court to do is ignore the use Meta made of the copies of plaintiffs' works and find that it acquired those copies in an unfair manner. But plaintiffs do not cite any case, and we are aware of none, in which a court made a determination as to whether the copying of work was fair or not, without considering why the defendant made the copies, what use it made of them, and how this use affected the plaintiff. By statute, fair use requires evaluation of the purpose and character of the use, factor 1, and the effect of the use upon the market of the original, factor 4. It just keeps saying use, and again, it's even called fair use. That misconstrues the basic tenets of copyright law and fair use jurisprudence and should be denied in full. That Meta intentionally removed copyright management information, oh yes, the CMI, from datasets used to train the llama models, knowing or having reason to know that doing so would conceal its infringement in plaintiff's books. God, this is such a stupid point. Stop making it. They acknowledge the reason why they do it. Because if they had put it in there, then when it would be producing text, it would just be hallucinating these random copyright notices on text that it generated and quoted from nowhere. Sort of like, if you remember the early versions of Stable Diffusion, how they would make up those fake watermarks diagonally across the image. None of them were actual watermarks. You zoom in, they're just blobs that kind of look like it. And Getty Images was like, see, that means it's copying our work directly. God, don't be stupid. But no, that's why they did it. This theory must now reckon with the facts. No reasonable jury could find that Meta violated Section 1202B for 3 independent reasons. 1. Unrebutted testimony from Meta employees and the party's experts conclusively established that Meta removed CMI from training data alongside other repetitive text. You don't want to put page numbers in there or, the book titles they have at the top of each page. You remove all that. As part of industry standard procedures to improve performance, the record is devoid of any evidence, fact, expert, or otherwise, or coherent explanation of how CMI removal conceals infringement. And 3, because nothing was concealed from plaintiffs. They suffered no harm from CMI removal and thus lack statutory and Article 3 standing. And so let's just look here on the last page. Well, not the last page is signatures, but... And it is undisputed that plaintiffs have long been aware of the very fact they now claim CMI removal concealed, that Meta used their books to train Llama. Thus, there is no evidence that Meta's CMI removal caused any concealment-based harm to plaintiffs, and it is not plausible that it could have. Alright, I've been talking long enough, but the point is well and truly made. Again, if this isn't fair use, then nothing is. And they can come after each and every one of us. I don't see this getting past the judge. I really don't. Because I've made several other videos about how ridiculous all of the other aspects are. And now here we have, this was actually a pretty good legal lesson in fair use. By now, if you've been watching this whole video, you are far more well-informed about fair use than probably a lot of lawyers are. Let alone those chuckleheads you keep seeing all over X. Oh, see that my book was in LibGen, that means they stole my book. No, they didn't. Shut up. Fair use. Just because someone used your book for something doesn't mean they stole anything from you. Otherwise, show me what they stole. Show me what you don't have now that you had before that they took from you. If you can't do that, then just shut up. That's what they all need to do. All these AI cases, lots of these other copyright cases, just shut up. You have nothing and you know it. So if you made it through all of that, thank you so very much for watching. Comments for the Comment God, shares for the Share Throne. Please hit like, subscribe, and the bell, and of course, donate.bogosity.tv. Keep me doing what I do, including becoming a regular supporter. You can get these videos early and ad-free, participate in live streams and AMAs. Thank you so very much for watching. Until next time, stay strong and be free.